Having regard to the challenge made to various provisions of the Hindu Religious and Charitable Endowments Act of the respective states, we find that the petitioners could be permitted to approach the respective state high courts to assail the said provisions, since the scheme of the respective scheme acts may be distinct. It is noted that in these petitions, the provisions which are under challenge are not only pertaining to the Tamil Nadu Hindu Religious and Charitable Endowments Act 1959, but also the Pondicherry Act of 1972, as well as the Andhra Pradesh Charitable and Hindu Religious Institutions and Endowments Act 1987. We find that a more effective manner of ventilating the grievances by the petitioners herein is to assail the provisions of the respective acts before the respective jurisdictional high courts, so as to enable the high courts to better appreciate the dimensions of challenge of the provisions of the respective acts. In the circumstances, we dispose of these writ petitions by reserving liberty to the petitioners herein to file their writ petitions before the respective high courts. It is needless to observe that if such writ petitions are filed by the petitioners herein before the respective high courts, the same could be considered having regard to the various dimensions of the provisions in light of the socio-economic, cultural, and religious aspects of the matter, which are all in essence historical aspects of the matter, including the judicial verdicts of the courts. The high courts are also free to constitute an expert committee, so as to have assistance of the recommendations said committee for the purpose of deciding the cases if they so think fit. These writ petitions are disposed of in the aforesaid terms.